All right, welcome back. So today we're going to talk about intellectual property, and really we're just going to talk about the basics in this type of lecture. There's another class where I get into a lot more of the advanced type of stuff, but I want you to have a sense of all the different types of intellectual property that there are and some basic estimates on cost. Now, a lot of these costs were, I think, at the end of about 2017, early 2018 timeframe. So, if this is later than that, you want to actually look up the cost for yourself from the different places that I mentioned when we're in here. The other thing I'm doing that's different than what a lot of people do in intellectual property is I'm going to give you kind of the entrepreneur and enterprise perspective. A lot of intellectual property is taught from the legal perspective, which is fine and dandy. It's important. However, you also have to make a business case for when it's appropriate to do certain things and when it may not be cost effective to do something. So that's something I also touch in here, which is very important for anybody running their own company or doing a startup. So let's get into it. So first, when we design something, we want to embody that design. And when we embody something, it may be something brand new, it could be a minimally viable product, maybe we're at a beta prototype stage, or maybe we have a fully viable prototype stage. But somewhere around this stage, we start coming up with ideas and we're far enough along that we could actually describe these innovations. We'd have drawings for these innovations and have an ability to seriously start considering and communicating the ideas that we've come up with. Because just as an idea stage is not far enough along to actually put in for any intellectual property, you really have to have the idea quite a bit more developed, particularly when you're talking about different products. Trademarks are a little bit less, but you still have to have those things developed. So really at the stage when you have this prototype, whether it be about beta, maybe sometimes alpha, that's when you want to see, okay, do we really want to protect this? Is this something that we're going to turn into a business or incorporate into an existing business? Now, the things that you want to make sure that you have before you kind of pull the trigger on this is the following. One, let me put my little laser pointer up here, is do you have your important components and do you kind of have your geometries down? That's really important, so you really have a sense of something that works and you've gotten through that component. Is the software architecture, is it set? Have you really done a lot of your code stubs, which meaning have you troubleshot a lot of the problems and gone through a lot of those things? Now, you're never going to get it perfect, but you at least should have a functioning prototype from a software perspective as well. You have to be beyond the proof of concept phase. Because again, that's still kind of just the ideation. You're really into where you've got something that's fleshed out. Budgeted items are roughed out. You've got a bill of materials that's forming and mostly solidified. It doesn't have to be completely there yet, because that's when you're doing a design for production. But you really should have all of your main components isolated in what's going on. You still have some details, but no major design decisions left. You're really kind of there. So at this point, you really want to look at adding intellectual property to your enterprise and your portfolio, because it's not just about having the product that you're going to sell, it's also about creating value in your company. And value is created when you add intellectual property to the mix. And it comes in several different forms and also can raise your valuations. In fact, intellectual property, in some cases, I've seen in some companies where they even leverage it if they're getting some bank financing, because banks look at IP and they actually put value on it. So it's another interesting thing to consider. So why intellectual property? Well, several things. It does give you some legal protection for profiting from your own innovations versus somebody else copying exactly what you've done and them trying to profit from the same thing that it took your team a long time to develop and put in place. There are legal repercussions for infringement. You can shut down other groups from using your intellectual property. However, you do have to do the protecting yourself. You have to get your own attorneys and things like that. That's something that a government agency doesn't do. Also, it encourages development of new ideas. And I put question marks on here. And we'll look as to why I put question marks there in a little bit, because there are certain industries where you're not allowed to do patents, for example, or you're not allowed to do copyrights, for example. and we'll take a look at some of those exceptions and see how that fits. So the major categories that we really have are trademarks. These are symbols that identify product, logos, phrases, company product names. We have copyrights. This is where you're protecting artistic works, things like books, music, lyrics, code. You have industrial design and patents. This is where you're trying to protect part of your design. Now, industrial design is really when you're looking at protecting a look or feel of a product. So you have things like iPhones that have their look and feel and maybe their interface design, those types of things. Patents are much more like a utility or unique algorithms, a unique process. You've come up with a new drug, a new material, a new device. That's a different type of design innovation. So that's where you're going to get some protection on that. And then trade secrets really is where you're keeping a secret. So we're going to look at more of these in detail. So to continue with that value of intellectual property, which again kind of answers a little bit of why we want to do it, it's this intangible asset. It's created by our human intellectual activity, a lot of different effort with a lot of different teams. There's a lot of capital, not only intellectual capital, but real capital that's spent into creating these types of technologies. It's a foundation for market dominance, actually helps you fend off competitors, those types of things. For Fortune 500 companies, for example, the value of IP ranges between 45% to 75% of their assets. That's a much bigger number than most people realize. Now, that's, for example, the World, and I didn't expect these to kind of pop up the way they did. The World Intellectual Property Organization, or WIPO, is actually where we look at how we govern intellectual property across the world. The U.S. office is called the USPTO, and we'll talk about that one in more detail when you're trying to do something that's just domestic and inside of the United States. But if you're doing something international or across Europe and most of the rest of the world, we have to follow the WIPO rules. Now, an interesting thing here is if you look at the discussion of IP. Now again, traditional idea is all the value is having all this intellectual property, having it protected. However, there's a cost, and we'll talk more about those costs in a second. So when you look at a company like Tesla, they've actually really rocked the boat on this because they've gone and decided, say, okay, instead of us spending hundreds of thousands of dollars for every one of these intellectual properties that we're trying to keep, we're going to not do that anymore, and we're going to say everybody can use it, and we're going to make it open platform. And we're just going to out-engineer everybody. We're going to keep innovating faster than others can keep up. They basically turned that on its head because the value of the stock didn't suddenly plummet once they did that, even though they opened up their IP to allow other people to use their intellectual property. So is that really an argument still there? That's something that is a good discussion to have because they really are challenging that model. And there are some good reasons for that. We'll look at in some of the other markets where it's wide open what the economic effects are of those types of things. So what are some examples of what it looks like? So if we have a utility patent, for example, so as you can see this old design, this was for the first Lego, a plastic Lego, and kind of what the design looked like and all those things. And if you look at modern day utility patents, it could be as to how the plug is designed, how the communication goes through this plug or power system, those types of things. For a design patent, the old Coca-Cola bottle, that's a very common design that they protected because it was their aesthetic. You associated that bottle shape with Coca-Cola, and not much has changed. They still have design patents for the newer types. Plant patents, a lot of people don't consider plant patents unless you're in the biotechnology space. You absolutely do, because now you're patenting a way to make certain plants, or maybe you've done some genetic modifications and you have certain strains of plants that are unique and different. If you look at like Honeycrisp apples, those were modified designs, and now they charge a lot because they've expanded their flavor and their size and all these kinds of things, and people pay a lot more for those than some of the other ones. So same thing with different kinds of grapes for different kinds of wines and things like that. Trademarks. These are symbols and or text. So you probably know what this trademark is right here without even me having to say it. It's the Nike swoosh. And believe me, they aggressively protect this. So if anybody has this type of symbol on their clothing or on apparel or anything, they will come after you because that's really what they're protecting. Copyrights. Again, if you have a book or if you have a creative work, this happens to be mine, you have a copyright to it. And then you either have the right to own it yourself or somebody else may own it depending upon how you do it, if you have a publisher or a company that does it for you. And then trade secrets. Again, this is just keeping things confidential. But you have to show in court that you are keeping things confidential. We'll talk more about that. Now for the first three, where we have patents, this requires a formal application. As for a utility patent, you have to show that it's novel, useful, non-obvious, not something that's been done before. And so it's not prior art is the term that's used. For a design patent, it's a little bit different. You're looking for something that's ornamental and design only. So it becomes the aesthetic and the certain shape, the feel or the texture, all those types of things can fall under a design patent. It's not as strong a protection as a utility patent, but it is actually used to preserve a way you do things and a way you do business with your products. Plant patent, this is called a new composition of matter. This is also the same thing with a new composition of matter that applies to new types of medicines, new types of drugs, whether it's biotech or typical pharmatech. All those types of things fall into that category. Trademarks and copyrights. This is where something that it may or may not have to be registered. For trademarks, typically you have to make a decision as to is somebody else going to come after you if you don't register it. Registration gives you another layer of protection that you've actively spent money to protect the use of it. You have a better case in court if you protect your trademarks and you register them versus if you don't. However, otherwise you can put things like TM. We'll go into this in more detail. For copyrights, you simply have to put the copyright on your works. And then that's the base level of protection for that. For trade secrets, it's obviously not registered because you're basically keeping something proprietary. But it also has to be useful, and you have to take great lengths to protect that. So let's talk about trade secrets first, because they're kind of the oddball out. Coca-Cola is the classic example. So in this case, Coca-Cola or whatever the company is, ABCD or ABC Inc., we have to keep it confidential. But what they're keeping confidential in this case is how are they making Coca-Cola? You know, what is that special secret sauce or secret ingredient that they're doing? And so they'll oftentimes keep those things in parts so that nobody in the company, other than maybe the upper echelon, know exactly what's in it. And also they probably have all these clauses to prevent somebody from going out where they'd be sued up to the millions for forsaking that or going out and trying to replicate it somewhere else. So it is a strategy. It's where you keep everything confidential, you keep it private so that nobody else knows how to make it or to do what you're doing. What kind of protection do you get? Well, it varies by country, state, or province. It does prevent if you're successful at keeping it confidential, but it does not block others from developing what you've got, which is also why you have things like Pepsi and RC Cola and some other colas that are very similar to Coca-Cola. Protection time, it lasts as long as you can keep a secret. So that's really kind of the limitation. If it gets out, it gets out. What can you do about it? So that's kind of what some of the challenges of it. You have to show that you're actively working to protect your trade secrets. You have to have non-disclosure agreements with everybody, even your own employees. You have to educate your employees, and you have to have confidential marketings on all sorts of the processes and things that you're showing, so that really you're having just as much internal paperwork and things of showing protection as you do externally. So it's really the process of a trade secret. All right. So the next video, we're going to be talking about trademarks and marks.